Welcome back. Of course, you're watching Morning Cafe, and this morning we are breaking down the complexities between annulment and divorce in marriage, basically the legal and personal implications that comes with these two, that is annulment and divorce. And to help me with this conversation is Evans Ndong, a public law, is it public lawyer or public law expert? BAS, public expert. I believe Evans has handled multiple cases and is writing currently about family law as well. And we just want to understand the battles that plays in these courtrooms when we're talking about annulment and both divorce. Karibu sana, Evans, to studio. Good to see you here again.
Thank you so much, Anne.
Of course, I know.
Quite a good chilly morning.
It is.
Yeah, we are here.
When I saw that, when I saw that you're coming, I was so excited because I knew that you would share very, very great insights into this topic. We have legal separation, we have divorce, and we have annulment. What are the fundamental differences between these three?
Thank you so much, and thank you so much, viewers. I believe it's a good morning wherever you are. We have rains in Nairobi, and we thank God for that. Yes, most of the times, people think that divorce is the same thing as annulment and as judicial separation. And I will begin with judicial separation because it then boils down all the way to when we get to annulment, when we get to divorce. There are sometimes, Anne, when a family is not sure, couple are not sure whether they want to really divorce or not. So what they basically do is that they go to court and petition under Section 66 of the Marriage Act and ask the court to separate them in the interim, temporarily, to give them a period of determining whether they really want to basically divorce at the end of the day. So judicial separation is just a declaration from a court or an order from a court, simply saying that so-and-so who is husband and wife will no longer live together. Let one live separately from the other. So they are just basically separated, but through a court process. That's why it's called judicial separation. And this process is always very important because it then allows parties to then have a discussion or reflect, because there are moments when one runs to file a divorce proceeding and then later realize, wow, this is something that could have been easily mediated. So that is always the role of judicial separation under Section 66. But when you go to Section 67 onwards to 69 of the Marriage Act, then there is divorce as a process. Now, divorce is the actual now point where two parties have decided that we have fully decided to part ways eternally, you see. Now, they go to a court of law and they have to satisfy certain grounds, such as adultery, the argument that the marriage is irretrievably broken down. And then the court will then issue a decree to the effect that they are now divorced, which means they are eternally separated. For judicial separation, note that it's not permanent. I mean, it's a moment of reflection, just to remove one party from that toxic environment and just ensure they reflect to decide what is the way forward. Now, to annulment, this is a very interesting process. Interesting because annulment are things that you did not know at the point when you are getting into the marriage setup, but basically come up later on. For instance, you get married to somebody and then later you realize that at the point of you people getting married, it was not of majority age. In such circumstance, the court will give an order of annulment. An order of annulment simply says this marriage was as good as non-existent. Why? Because it did not follow certain processes. And I've just given you an example. If you get, there are like around 6 grounds to which a court can annul a particular marriage. The first one being that if the court, if one party discovers that at the point they married the other party, that party was not of majority age, it means that they were not eligible to get into that institution of marriage, and therefore that marriage is as good as non-existent in law.
What age is this?
18 years. I mean, only adults can enter into marriage under the Kenyan law, under Section 4 of the Marriage Act. So there are circumstances, and we know the complexities in our communities, especially for customary marriages, where one party realizes, oh, at the point I was getting married to this person. He was of person below 18 years. And therefore, that marriage was as good as not existing. So annulment is an order that is being given on the fact that the grounds or the capacity to enter into the marriage as a matter of first instance were not met. Or there are circumstances when the marriage has not been consummated 12 years down the line. I mean, nothing is coming up. That is also a ground for annulment. There are also circumstances where you realize that one party was in a prohibited relationship, and a prohibited relationship can take so many forms. One, it can take the form that you have gotten married to a person of close consanguinity. You realize this person was your relative. You discover it later. Then the marriage will be annulled. It will not be a divorce proceeding because a divorce proceeding presupposes that there was an existence of a marriage setup. But an annulment comes when that marriage was nothing from the beginning. Parties were not eligible as at the point they were entering into the said marriage. That is the difference.
Is that all when you're talking about grounds for annulment? Because I read somewhere we also have something to do with the fraud.
Definitely, that is also. There are several grounds really that I mean get to arise, but yes, fraud is one of those grounds. If you realize that somebody entered marriage through deception or the marriage certificate was deceptively procured, that is a sufficient ground, you know, for a court of law to annul that kind of marriage. There is also the issue of consummation, you know. You realize that ever since 10, 12 years you have been in marriage, there has never been consummation. That is, you know, part of the evidence that the Kenyan marital system still looks at marriage as part of the role of marriage is childbearing for continuity. So if there has not been consummation, then that marriage you know, can be annulled. Another ground is also when you realize that as at the time one party, I mean the lady is entering into the marriage setup or the wife is entering the marriage setup, they are pregnant, you know, they are expectant, and it is discovered that they are expectant without the knowledge of the other party, and that the other party is not responsible for that pregnancy. That is a ground for annulment under Section 73 of the Marriage Act.
So does time limit the right to seek an annulment in any case?
Definitely. Section 73(2) of the Marriage Act gives a time limit, and it gives a time limit of 1 year. However, I need to put a rider to that, because Justice Nyakundi in the High Court actually declared that provision unconstitutional for the very reason that it tends to tie parties. Okay? For instance, it does not make sense, Anne, that you can discover your marriage certificate was procured by fraud, but you then have to postpone that fraud for 1 year limitation to occur in marriage, then for you to seek for annulment. It also doesn't make any logical sense. For instance, if you realize that somebody was married as at the time you are getting into the marriage, and the system of the marriage is monogamous. You know, monogamous, the Marriage Act says when you're in a monogamous setup, you cannot add another wife. You cannot, you know, remarry, you know, unless you officially divorce your current wife. If such a ground meets the ground of annulment under Section 73, the High Court was simply saying, look, it doesn't make sense that we can postpone that for 1 year, you know, for a party to then seek annulment. Although Section 73(2) says one has to wait for 1 year, but that provision has been declared unconstitutional, and Parliament has so far not rectified Section 73(2). So we have a lacuna in law, but I think it's a good lacuna, because right now we can authoritatively say there is no time limitation for annulment of marriage.
All right, this is a very interesting conversation, but you know, I want to invite our viewers to be part of this conversation. There is a line on a number on your screen. Call in. We will be very, very happy to hear from you. Send in your feedback as well on X or at TV47 News KE, and on Facebook and YouTube at TV47 News as well. You know, when we're talking about judicial separation, Evans, you talked about one can marry again now that court just declares you're separated, to think about it. Annulment, I believe one is able to remarry, but with divorce, is this really possible?
That's a very interesting distinction to then create. For annulment, yes, you are correct. Once your marriage has been annulled, it means you are being told, the court is telling you, this was not a marriage in the first place. For instance, if you look at the ground of age, if you marry an underage, that is not a marriage. The law does not recognize it's illegal. So it was not a marriage in the first place that can go through a divorce process. So for annulment, you can remarry. Now, for divorce, you can actually divorce and remarry. Once you have formally divorced, the court has finalized the process, you can remarry. For judicial separation, it's a bit more interesting because the court has not declared that marriage eternally apart or
null
asunder, you know, null and void. The court is simply saying, you people are still married, but are living separately. And it must be understood why the court sometimes does this. And the court does this, for instance, if one party claims that, you know, they are not sure that they are going to divorce somebody, but their life is in danger, or that the environment is toxic, or that it has taken a toll on their mental health. The only thing the court does is to, if one party seeks a judicial separation, is to ensure they are, apart. Meanwhile, so it means, therefore, that you can't remarry, especially when you are in a monogamous setup. The Marriage Act does not allow you to remarry. Because if you remarry, it almost presupposes that you are not married in the first place. You know, you can only remarry in judicial separation if you are already in a polygamous or potentially polygamous setup.
Now, what happens to that couple after annulment, Evans?
Now, this is, it's quite dicey, I mean, to think about. Because after annulment of marriage, I mean, it's the end. It's the end of the road. So the only thing the only exception that I see the Marriage Act, putting, if the ground of annulment is basically solely on consummation, then the courts have said that if between the time the petition is presented and the time it is actually determined by the court, consummation has taken place, the court will not annul that marriage only on that ground. Yeah, because then, you know, the issue would have been cured already if it was only on that ground. But basically, Anne, I mean, if a marriage is annulled, that is the end of it, it's the end of the road. You either go look for another spouse or something else. Yes.
You know, as of 2023, I was reading that Kenya recorded a low divorce rate at just 0.6%, 0.06. Do we have a current data on the rate of divorce in Kenya? Or if you're looking at 0.06%, does it mean Kenyan marriages are stronger? Ama people are dying in these marriages, they just don't want to walk out?
No. I think I've looked at all the statistics from the Kenya National Bureau of Statistics. I think my only issue is, I believe the Kenya National Bureau of Statistics has been using those registered marriages. And that's where the problem is. You know, if you actually collect data and do statistics outside here of marriages that have not been registered or customary marriages, you can imagine, I mean, the Marriage Act told us to register our marriages by latest 2020. There was a Gazette notice to that effect from the Office of the Registrar of Marriages. But then since then, and you can imagine my mother or my grandmother in the village, I mean, these people have been married for 40 years. They don't even recognize that registration piece of paper as part more binding than the union that they have. So I think it's not true that divorce processes have reduced. I think divorce is on the rise, and part of the reason is, I think there is a wave that is running in the country, in most African countries, to be specific, around the East African region, where marriage is now not looked at. You know, the Constitution says is a basic structure of the society. But I think we are tending to look at marriage as more of a contractual, kind of engagement, like it is in the West, where once the purpose of that contract is done, you can always just opt out, you see. And I also think that there has been high prevalence of GBV, domestic and gender-based violence that is now leading to the increase of divorce processes. So I don't believe that the Kenya National Bureau of Statistics data is based on all the holistic view of all the marriages that are subsisting in Kenya. I believe that data is based on registered marriages, which quite you can tell, I mean, sets a very small percentage because of most Kenyan marriages are basically customary in nature. But I think there is another coin to this. I believe our hard economic times have also contributed to the divorce rates that we're seeing in this country. I mean, you can tell the way things are going in this country in terms of economic wise. And I said marriage is being looked at as a contract. So if you don't have something, if you don't have the money, you just realize this thing is not working, or you have the money, you get into a contract or marriage, financial constraints gets in, and then the other party just opts out. Yeah.
So would you say that most Kenyans just stay in marriage because it's legally binding when sometimes they just want to opt out of it?
I think, Anne, the truth is that there is the societal flip side of marriage, which still holds a very high sway in our societies. There is a premium that is being placed upon those who have gotten married or those who are in the union of marriage. In fact, the traditional view is that, you know, even if things are not working, you need to stay. You know, you need to stay because the societal structure, you'll be told, we need your offspring. I mean, you know, you need to stay for continuity, generational continuity, and all this. So I think, in my view, most people stay in the marriage setup because of the social status that comes with it, you know. But ideally, many marriages are irretrievably broken down, and for good reasons that I've already spoken to. Economic reasons, some of them social reasons, some of them just personal human, you know, fallibility, you know. So I think the controlling factor to the Kenyan marriage setups right now is the commercial aspect.
You talked about GBV, and I'm interested to know if, when you're talking about domestic violence, for instance, is it a ground for annulment per se? We have things like my spouse, let's say, he's an alcoholic to an extent where maybe he cannot function properly at home. Is that a ground for annulment? And also, when we look at this issue of domestic violence?
Definitely. There are not explicit grounds when you look at Section 73, but courts have increasingly interpreted the things you've said into some of the grounds. For instance, when you say the marriage is irretrievably broken down, I mean, there are cases that I've seen in court where one party is excessively taking alcohol, I mean, or drinking or abusing drugs to the extent that they are not able to perform not only their marital duties, but also take responsibility, you see. So they are not explicit grounds under Section 73(2), but they are actually grounds if you look at the ground on marriage being irretrievably broken down, but also deprivation. I mean, there are certain, sometimes conjugal rights, sometimes, I mean, just responsibility that somebody is supposed to undertake. If the court finds that there has been acute deprivation and one party is not able to demonstrate that they are living to the task of being a party to that marriage, the court will actually annul that marriage. But also importantly, you have talked about GBV, which gets into the ground of cruelty. You know, part of the grounds of annulment and of course divorce or even judicial separation that runs across is cruelty. And cruelty can be verbal, I mean, cruelty can be physical, cruelty can be psychological. Cruelty can be deliberate, you know, economic separation. You see, there are families where one party just decides, I'm not going to release any funds to support the other party. You know, people have financial arrangements and, you know, a family decides one party wants to take care of school fees, another one wants to take care of, let's say, rent. And then one party decides to withdraw completely, or in certain circumstances, the party who is the breadwinner, who is the sole breadwinner, decides that they are deliberately going to suppress the other party through the economic route where they are not releasing, you know, any support. That is actually part of cruelty and deprivation, and can actually be an evidence that the marriage has been irretrievably broken down.
And you know, our judicial system, sana with these issues of GBV, domestic violence, before they rule out on such cases, they ask, maybe they put it aside because they see lack of enough evidence. When we're talking about annulment, does that come to play? It's just as easy as 1, 2, 3?
It depends with the grounds, and this is now the most interesting part with annulment. Annulment, unlike divorce, you don't just throw grounds around. You must they must actually be credibly backed because the court, you are seeking the court to say, Anne, that there was no marriage in the first place. Yeah. You're not saying we were married and now we want to separate, allow us to separate. No, you're saying there was no, for instance, if you're arguing that one party was in a relationship that is prohibited, was in another monogamous relationship when they wanted to get into this, do this church wedding or whatever, the court actually makes a finding to the effect that, look, there was nothing here in the first place. This was not a marriage at all. So, if the grounds are ones that are actually legal, like age of majority, you know, somebody being in a prohibited relationship, you know, that the Marriage Act does not permit, then you must have very credible evidence. In fact, there are circumstances the court will find that, in fact, there is no credible evidence to annul such kind of unions. Yeah. Because annulment is simply saying there was nothing here in the first place to even dissolve. Yes.
That happens with customary marriages as well, right?
Definitely, and for customary marriages, and because you see, the Marriage Act again says under Section 43 of the Marriage Act that token dowry is enough to prove that
you're married.
You are married. I mean, to prove customary marriage. Actually, the Act is specific that token dowry is enough proof for customary marriage. And Anna will take you down the memory line why it is so. You know, in our societies, the manner in which marriage were being, unions were being formalized in terms of marriage, it was not formalistic. You know, the registration requirement only came later. In fact, if you look at Section 44 and 45 of the Marriage Act, the notice that you give to the registrar of marriages when you want to get into a customary marriage, the Act says that you give notice to the Registrar of Marriages to show that the processes, the cultural, customary processes have been undertaken. So which means that as at the time you are going to the Registrar of Marriages, we already have a customary marriage in existence. The requirements have already been met. So the law recognizes customary marriage to be in existence way before registration. Registration does not give it legitimacy. It's already in existence. So annulment of customary marriages are actually sometimes very tricky, you know, but possible. For instance, there are communities in this country that we know have been marginalized for a long time, where you find most of the children, most of the young people, the youth, they don't have IDs. You know, they have not applied for IDs for one reason or the other, or their process of vetting for IDs has been very difficult. How do you determine their ages? You know, when we know that the identification card is actually the main requirement for that. So for you then to come back and prove that this person was married off when he had not been of majority age then becomes an assignment, you know. And that is why I think the law requires now under Section 59 that all systems of marriages be registered. Yes.
So when a marriage is annulled, does it in any way affect the legitimacy of the children born within that union?
That is an interesting question, and it's one question that I believe very soon the courts will pronounce themselves, because I've seen several cases of that nature, you know, pending before the High Court as of now, you know, as we speak. The idea with children is that when you look at Article 53 of the Constitution of Kenya, is that the best interest of the child trumps up on everything. And so even if you annul a marriage today, that does not take the responsibility of parties towards children, you know, that came out of that union or so union. I mean, whether now it's finally found it was not a union at all, I mean, but at the end of the day, the interest of the child will trump every, and it's the same for marriage, I mean, for divorce, and judicial separation. And you don't say that because the court has decided that the parties are divorcing, I'm no longer taking responsibility. You don't even say that, look, this was not a marriage at all, but we got children, and so we'll not take care of these children. The best interest of the child under Article 53 overrides every consideration when you are dealing with children. And so, whereas annulment, divorce, and judicial separation can all affect children, it does not take away the responsibility of the parties to that, because now they are parties, they are not now a couple. You know, once a divorce has taken place or once an annulment has taken place, they are now not couple, they are parties. You know, those parties have a duty to take care of the child. It is always, and actually the Children's Act is clear, irrespective of whether marriage exists or not. Children and their responsibility under Section 32 have to be taken care of. Section 32 of the Children's Act, they have to be taken care of regardless. And some people have even thought, Anne, that it was the reason why Section 73(2) on annulment put a time limitation of 1 year. Because the thought process was, well, it would also not make sense for somebody to come back 30 years later and say, look, when I married in the year 1980, you were not of majority age. You know, I think it was the thought process around determining legitimacy and paternity of children. But at the end of the day, I don't think it's an issue anymore, because children, their interests will always be catered for.
So how does the court really now come to decide on child custody when you're looking at the issue of also paying child support? I see this happens a lot with divorce. How does it work in annulment now when the court needs to decide on who gets custody of these children?
Now, that's and I said this is a new area that is utilized. But of course, we can always borrow from what happens in marriage and judicial. It's no different when you're dealing with children. I think the determination of who is supposed to take care of the child, because see, being a mother of the child does not end because of marriage. So that's why Section 32, because of divorce or annulment, that is why Section 32 of the Children's Act talks about equal parental responsibility. It does not talk about equal couple responsibility, because it actually recognizes the idea that the responsibility of a child does not depend on you two being couple. The only thing it depends on is one is a mother, one is a father, or one has accepted to take responsibility. You know, the Act also allows you, if there are children you have taken in your custody and are accepted to take responsibility, the Act recognizes them to be your children. So you will actually have to take care of them. So the determination of who is supposed to take a child, to take care of the child, is arrived at first on an assumption that both parties first have equal rights to take care of the child. Then it boils down to the court making an analysis of who has the best interest of the child as of this time. I have seen cases, and I would tell you, Anne, where the father is in the United States of America, the mother is in Kenya. The child is getting his or her education in Kenya. Courts have been very restrained to give the order of custody with the parent in the United States of America, because the main factor, Anne, is that whoever is being given the child, the situation, the surrounding environment must be in the best interest of the child, number one. Number two, it must not interfere with the ecosystem of the child. Things like schooling, things like environment, a social, and cultural shock. If you take a child who is studying in Kenya here, is going to the next semester, and then you take them to the United States, you can see that disruption in terms of terms, their school terms, semester. So the trumping consideration is the child's best interest, Anne.
And I'm wondering now, what happens in terms of child support? One parent has been given the child because he or she maybe has the best interest of the child at heart. But the other party is not cooperative. Let's say the one who is financially stable and capable of taking care of this child. Now, what happens in that particular case now that when we're talking about annulment, the court has declared that this marriage never existed at all?
Again, I will say it again here, that the responsibility to take care of a child is not determinant on whether there was a union or not. It only determinant whether you are taking responsibility as a parent, and that informs Section 32 of the Children's Act.
So one parent can be sued for not paying child support?
Definitely.
In an annulment?
Definitely. One parent can be sued because the responsibility is irrespective of marriage. It's irrespective of marriage or whether a union existed or not. It's actually on paternity. Is this your child? Or did you accept to take their responsibility? That is what matters. So there are two instances. When the court annuls a union and makes a determination on how parties are supposed to contribute, whether to the ratio of 70 to 30 or 40 to 60 in a marriage setup. The question that will be asked is whether each of those parties are taking their responsibility as ordered by the court. If one party is not taking their responsibility as ordered of the court, you will actually make an application for contempt of court. Yeah. Contempt of court, why? Because the court has given you an order as a father or as a mother, but be contributing 70% to school fees or whichever the court. There is a way the court delineates them based on the evidence, or what we call affidavit of means. Affidavit of means is where a party says, this is how much I earn, this is how much I'm able to take responsibility of. But of course, the court is not bound by those averments. The court will make an order that is just and in the interest of the child. Yes.
You know, I'm also wondering, in a situation where one party wants this annulment, the other does not want. Maybe a Turkey, because of psychological incapacities that he or she doesn't want to agree, that they're struggling mentally or they are violent in one way or the other. What does the court do now in that case? Does it offer restraining orders to this other party, or what happens exactly?
You see, Anne, courts have said time and again that if two parties don't want to live together, you can't force them. And
one wants to live with this other person.
But understand, I'm coming to that.
Okay.
And so because you can't force two parties to live together, let me tell you, Anne, the fact that one party does not want is enough evidence that, in fact, that marriage is not uniform or that union is not uniform. So ideally, Anne, you see, even in divorce proceedings, in Kenya, unlike India, if you look at India, Section 10 of the Christian Act, Indian Christian Act, gives voluntary divorce and voluntary annulment in India. You can actually decide, wake up one day and go to court and say, we want to annul this marriage. We didn't believe in it from the beginning in India. But in Kenya, there is no voluntary annulment. There is no voluntary divorce. So it means, either way, whether one party wants it or not, once a party goes to court, the other party has to respond. But now what the court has been doing to mitigate such circumstances that you refer to, where one party wants this and the other party does not want, what the court normally do, the court normally takes this through what is called ADR, Alternative Dispute Resolution Mechanisms. In fact, what the courts have done nowadays for most children and family matters is to always, as a matter of first instance, ask the parties to resolve that matter through a mediator. First. If they cannot agree on the mediator's table, then they present themselves to court now for full determination. But mere reluctance or refusal by one party cannot deter an annulment or a divorce process.
All right. You're talking about something that it doesn't make sense for someone to come back maybe, say, 30 years later to claim this child. But I was listening to a certain video. It's a case where the lady died. 15 years later, they were separated. I'm not sure if it's legally or just a mutual agreement to separate, but now the lady died. But let's just go back a little bit. She got married to another man, gave birth with that other man, but initially she had children with this other guy who they apparently separated. So when they died, this man came back later to claim custody of the children and of the estate of this lady. Is there a case there?
There is a case there from whichever angle you look at it, yeah? Because we go back to Section 73. Section 73 says you cannot be in an existing marriage and contract another marriage, especially if it was monogamous in its form. You see, the fact that a marriage has been declared monogamous, Section 8 and 9 again of the Marriage Act, prohibits certain relationships. And, you know, many people don't know that you can actually, if you are already in a polygamous setup, you can actually continue being polygamous. Okay? But if you are, you know, you can continue being polygamous. Or if you want to be monogamous, if you want to move from monogamous to polygamous, the condition is that you must have one wife. So if you have one wife and declare that I am moving this, then it's possible. But you cannot convert from a monogamous system to another polygamous setup. So if that marriage, it will depend on so many factors. If it was a monogamous setup, what will happen is that, look, Section 73(2) kicks in. you cannot be in a monogamous setup and contract another marriage. So that is a ground ripe for annulment. So if the court, if they just merely separated, it means they did not divorce. So if they merely separated, the other party had no capacity to get into the next marriage. Therefore, on that ground alone, the court will assume that indeed there was no marriage in the first place. But does that affect the custody and maintenance of the children that were left behind? No, it doesn't. Parties under Section 32 now of the Children's Act will still be recognized, either or the other, the mother or the father, to be having the responsibility of custody and maintenance. And in fact, in the setup where now one party has died, then automatically there is no doubt that the other party will be able to take care of the children. Yes.
So now that there are two husbands, as you're talking, because there was no annulment done with the other party 15 years ago now. So who takes care of this property belonging to the late? Is it the current husband or the previous husband?
Now, that's a different thing, you see. And when you talk about now succession and inheritance, then a new act gets into being, the Law of Succession Act. Okay? Now, the question that will be asked now is whether the former husband, the other husband, can be legitimately be called a former husband in the meaning of the Law of Succession Act. Because Section 29 of the Law of Succession Act delineates, who is a former wife, who is a former husband. You see? So that will be a determination that will be made in the preliminary. If the Law of Succession recognizes them, and how the Law of Succession operates is very different from the Marriage Act. It's not even affected with whatever happened in the marriage setup. What the concern in the Law of Succession was whether legitimately this other person could be called a dependent under Section 29. Can this other husband be legitimately called a dependent? Now, spouses do not have to show that they depended on the deceased person as a matter of maintaining them. The nuclear family, children and the spouses, they don't have to show that. So the question in this place will be whether the former husband is actually a dependent in the meaning of the Law of Succession Act. Then they will be entitled. That is a determination that can only be made through a court process. Yes. But for children, custody and maintenance, the court will only ask itself one question. What is the best interest of the children? Is it in their best interest that they live with a new husband? Upon, for instance, showing that the former husband has neglected duty for some time and has only come on board for the purposes of the wealth that is remaining. So the court processes are able to sieve through this when evidence now is being tendered. And this is why I tell people in family and children matters, keep the receipts.
Receipts important.
If somebody was being maintained, if somebody was sending 20,000 shillings per month, 10,000 shillings per month, and telling you, oh, use this to go make your hair, use this to go take care of the children, use this to go buy a suit, keep those receipts because they'll come in handy.
And this gets me to this other question. Who gets it easy when you're talking about annulment? Is it the men or is it the women?
I'm not in a very solid position to make that determination. It depends, would be my answer. But I think if you look at it from a gender perspective and paternity questions, then there is a gender dimension to it. Women could be largely affected. Why? Because emotionally, women are attached to their children, and they attach more emotions to the marital institution than the gentleman. I don't know whether that's a fair assessment, but I think so.
So do annulments and divorce have different implications when you're talking about property division?
That's interesting. Now, they have different implications for just one simple reason. There is something called prenuptial agreement within the Marriage Act. Parties can actually get into marriage with an agreement on how they wish to actually share their liabilities and assets in case it doesn't work. It's a risky move, but it does happen, just like Kenyans and many Africans are afraid to make wills because they believe you'll die soon.
Do you recommend it, prenups?
Yeah, prenuptial agreements are very important. They're very important, especially where there is vast property that is involved, because this long battle of 12 years in court over property would actually be solved in a single stroke of a pen. But I say the difference in terms of property implication would be in certain situations in divorce, there are people who have signed a prenuptial agreement. So then the court will not have to determine, you know, the percentage of parties and all this. The court will only interfere with the prenuptial agreement if the court finds that that prenuptial agreement is in fact unfair in law, you know, but the court will not ordinarily interfere with parties. Unfair in law means the property divided in such a manner, for instance, where it doesn't cater for children. That would be unfair in law. I mean, the court will interfere with it, you know. But for annulment now, it's very different, because for an annulment, even if there was a prenup to that institution, that prenup is not binding. It dies because it was built on the foundation of a contract that was not a contract at all. You know, a union that was not a union at all. So what the court simply does is the court will then issue division as though that was a contract. You'll actually just check, it's like a business partnership now. Just check who contributed what and in what percentage. And that's what the Supreme Court actually did in 2023, when it actually found that there was no marriage, okay, in one marital setup. The court asked itself, now, should we leave parties to be the way they are? No, the court said no. We can actually get evidence that, this person contributed, you know, took a loan to buy the rentals, to build the rentals, develop the property where. Upon making those considerations, the court said, no, we now want to handle this as a normal contract. Let us share this according to their contribution. Let's give one party 70, and the Supreme Court gave another party 30%, without reference to marriage. Yeah.
All right, we have a few questions here. I want us to take a look at a few before we close. Casper is asking, does annulment come with the same consequences of divorce, such division of property? I think I've asked that. Is annulment as tedious as the divorce process? This is Patrick.
Whether annulment is as tedious as I think it is, and I think it's even more tedious. It depends with what tedious is. I think annulment, because it calls for a higher threshold. I mean, you are telling the court there was nothing here. So it called for a higher threshold of evidence, higher threshold of time, you know, and analysis. But I think divorce comes with the baggage, a lot of emotional baggage, especially with our dragging judicial system. And that's why actually, Anne, in 2023, the Supreme Court again told us it is not in the interest of children that court processes drag for like over 15 years, because you can tell the emotional toll that it takes on children. So, well, on tediousness, in terms of the threshold, annulment requires a very high threshold to tell the court there was nothing here, as opposed to marriage, as opposed to divorce. Because for divorce, courts will be very reluctant to leave parties in a union they don't want to be in. Yes.
Malaba is asking, how much will it cost if I file for an annulment, and how long will it take to process? I was separated for 9 years. Can you help me?
Now, Anne, interestingly, there is no timeline to determine family and marital matters. You know, as you see timelines with other things like elections, petitions, 6 months. I think there is now currently a push, and for those of us who are pushing for policy reforms within this area, we are saying, because children are involved in this process, provide a timeline upon which courts are supposed to determine family matters and also children matters. So there is no timeline. One cannot promise a timeline. It all just depends with the backlog in that division of the court as of that time. Now, as to cost implications, one wouldn't tell until we see the complexity of the matter.
All right. Time is not on our side, but I want to read this comment from Ruth. She's saying, if they believe that he wasn't in sound mind when he married his wife, he does not love her from the start, he can't sustain the marriage anymore. Can it be, can he file for an annulment?
Definitely. Section 73(2) again comes in. It provides for insanity as a ground, you know, especially 73 now 1B, A, B, and C. Yeah. So insanity, if you realize that the person you got married to as of that time was not, you know, the act says intermittent insanity, then Definitely.
Yeah.
Can file for annulment.
Evans, you know, we have a lot of feedback here, but just to, as we wind up,
Yes.
And of course this should also serve as your final remarks. So
Yes.
you do actually recommend that before someone gets into another marriage or relationship, they should first of all annul their previous marriage?
Definitely, you either divorce or it was annulled. Okay.
Divorce or have it annulled?
Yes, divorce or have it annulled. Divorce, why? Because if you are divorced, it means you're free. You can actually get into another marriage. You're not into any setup. If it's annulled, the consequence is non-existence. It's non-existent. Actually, the consequence of annulment in divorce is actually the non-existent, because we are killing the marital institution to death. The only thing is that in one case, we are saying we are not killing it. It was not there in the first place, and that is annulment. But I think what is important is this, Anne. I think Kenyans need to realize that we need to divorce our emotions from marital issues, especially legal issues. Before somebody gets into a new union, do due diligence as though you want to buy land.
Yeah.
Do due diligence as though you want to buy land.
Thank you so much. That is Evans Ndong, a public law expert, helping us in breaking down this complexity when we're talking about annulment and divorce in marriage. Thank you so much, Evans, for the great insights on this particular topic. It was lovely to have you here again.
Thank you, Anne. I'm happy to be here.
All right. That brings us to the end of this conversation and to the end of Morning Cafe. Thank you so much for staying with us. Good morning. See you tomorrow, inshallah. My name is Anne Odida.